Hi, good evening. Today it is December 2nd, 2025, and it is 8 p.m. US Central Time. Just one second. My name is Rinaldo J. Aguiar Marcano, and I'm recording this video from my home located at the 2302 Britton Ridge Drive, Katy, Texas, 77494. And this house is located in a gated community called Lake Point Estates. And the house specifically is located 300 feet away from the house of a gentleman by the name of Mr. Robert Mueller, who was the director of the FBI for several years ago. And that is very relevant to this conversation. Yes, so I want to make I'll explain why in a second, but I want to make a quick mention, right? It might sound like promotion. It's not really promotion. I'll explain what it is really in a second, but I'm going to say that if you're interested in learning more about this network that I've been documenting for the last 6 months in these videos, you can go to YouTube and look for the channel called Rapid Fire Tips, all together, Rapid Fire Tips. All the videos are in that YouTube channel, posted chronologically. Or you can also download the book for free the book contains the transcripts of all these demos. And that is at the following address, the spyhealthfiles.com/IRS. I as in India, R as in Robert, S as in Sam. If you go to that address, you will be able to download all the transcripts of all these demos. So with that, I'm gonna get started. So this is demo D91-3. So this is the third part of a 3 parts demo series that I've split into multiple sessions because it was a long, it was a long, not only because it was long, but also because it had different topics that fall in different categories, and to make it so the content was distributed in a way that makes sense. I split it into 3 parts. So this part is going to be focused on a couple of things. Like it's going to be heavy on the legal topics, and these are observations of legal topics that have to do with this conflict that I have with the Communist Party of China. Really, right behind the scenes, it's them, right? That I've had this conflict with them for 20 years at this point, right? But it has escalated until this point, right? Where it's, all these litigations in these different courts. So I'm going to talk a lot about that. So it may seem like something that it's not applicable to a lot of people, right? Because it's very localized to legal conflicts and specifically in the Texas courts. In Texas, because that's where I am, right? That's where I live. Me and Robert Mueller, right? We both live in Texas. But I want to say that despite the fact that it might look like these things might not apply to you, I would like to invite you to watch the videos and analyze the content and the ideas yourself, because although this is a localized conflict and these specific observations are about a localized conflict, this might as well apply to you, right? Because this is a global network and they're doing the same to everybody around the planet. Like they have develop these techniques of harassment, legal and otherwise, in a way that they're applicable and they deploy them everywhere, right, to everybody. So the specific rules of procedure that they might be attacking you or your family with in the legal area, if you're a target, might be slightly different, right? Because if you live in a different country or a different state, the rules of procedure and the things that they do might look slightly different, but the principle of the attack is the same. I can put my money on that. If I was a betting man, I would bet that's the case. So it's an interesting thing because it's a localized So this demo is very localized, but the ideas are generalizable, and they have generalized it, right? And that's the way they scale their operations to planet scale. So that's that's just a brief comment about the content on itself. So I would like to start by saying, right, that for this particular demo, I have an objective in mind, right? So besides talking about these specific things and observations, right? I think that, or I hope, right? I don't know if this is going to be the case. Maybe it has the opposite effect, right? Maybe people run away, but run away from this, right? But my hope is that maybe young people, like younger generations, people that may watch this specific video, by listening to the things I'm going to say about specific technologies and techniques, about distributed computing and search ranking that I'm going to touch on this topic, on this demo. My hope is that I don't know, some of the young people that may watch this video become inspired by this and may choose to consider pursuing a career in this area, because the world needs a lot of people that can do this, and the world will need you to do this for several decades ahead of us, right? Because they are not going to stop doing this, and they have had 25 years of a head start developing people and talent to do this, right? So it's a tremendous imbalance. And just a side note, through my years at Google, right? Because I had the opportunity to learn these things because they employed me at Google, and they put me in positions, in key engineering positions, in key teams, but to fulfill their own agenda, right? To so I would develop technology, and they would steal it for companies that were not Google, right? But besides that, during my tenure at Google, I've always asked myself the question, and before even knowing that I was under surveillance, right? Like for years, I always asked myself the question: why is that these techniques of distributed computing and information retrieval systems, right, that are so at the heart of Google search, are not taught in university anywhere, right? It always struck me as a tremendous disconnect between industry and education, and I couldn't understand why, right? You would think that educational system would try to follow industry, right? That's the natural thing to do. But now I understand, right? I understand that it wasn't a mistake, and this is a hypothesis, right? But I think I understand why. It's because these techniques of information retrieval systems are really a weapon, right? Like they are being and have been weaponized for 2 decades, right? And they don't want anybody to have that knowledge, right? So that's why they keep it in a tight circle. Like only a handful of, don't think that every engineer at Google knows these things. It's a very tight circle. I would put it, I don't know, around maybe 100 engineers across all Google have access to this knowledge at this level, right? And of course, nobody in any university teaches this because it's just a knowledge that is not available outside of that tight circle, right? So, and that was perhaps the biggest strategic mistake they made, right? Like they taught me these things. If they hadn't taught me these things, I wouldn't be able to do this today, right? But anyhow, my hope is that first that young people that may eventually watch these videos, see beauty in this area of knowledge and pursue it, right? And also that people that regulate, or that I don't think regulate is the word, but people that shape education, right, or educational systems, see the importance of putting emphasis on this area of knowledge, and teaching everybody that wants to pursue this career, teaching these things. Right? Because as I said, the world will need a lot of people that knows about distributed computing and information retrieval systems specifically at a scale, right? For the decades to come. So for this demo, I have kind of split the things I want to talk about in different categories, right? So my game plan for today is to start high level, and then I'm going to go, after I do that, I'm gonna go into a lot of on the ground observations that have happened I would say on the last 3 weeks, right? And they've been queuing up. So I'm gonna deliver those in this demo. At the end, right? And I'm gonna go through them quickly. I'm not gonna, get into much detail, but I'm gonna record them for the record, and in case authorities watch this video, they have something to, there might be leads, right? Interesting leads. So I'm going to humbly offer them and record them in this video at the end. So the first thing I would like to talk about is about asymmetry, right? And specifically information asymmetry. And this is a concept that I've went into details in the books that I've published, and how the network uses information asymmetry primarily to manage their own agents, right? And the idea is, they don't tell all the agents everything, right? Like the people at the bottom of the pyramid. Like, let me start by sharing my screen with you. So I'm going to do this. Okay. So as we mentioned before in one of the demos, societal systems are hierarchical. So imagine that let's talk about their society, right? So their bizarro state. Before I say this, I want to clarify something in this diagram, right? Because when when I represent this, and I went over this diagram in the previous demo, but when I represent these two triangles, right, the gray triangle being the real society and the red triangle being the bizarro state created by the Communist Party of China, because of the way I chose to represent it, right? So be able to put the arrows and represent the same level attack. It looks like, visually, that the bizarro state, this, parallel society they have, is outside of our society, right? But that's not really the case, right? Like, and that's the big danger, right? Is that this, in like the reality, right? Is that the society is embedded. If I wanted to make a accurate representation of this, the society is embedded inside of the real society, and the arrows would be represented in this 3D way, right? But it's a representation that is more harder to see visually, right? So that's why I choose to put the triangle outside. But I'm not saying that they're not part of society. They are part of society, right? Like Elon Musk, he's part of society, of the real society. He's on TV, right? But he's playing for the other team, right? For the Communist Party of China. Yes. So the what I wanted to mention about asymmetry, right, is that in the context that I've described it in the books, is that let me make a new slide to cover it. I'll delete it because this is just to explore this idea, right? So imagine that this is the bizarro state, right? Like this parallel society they have where they have all these agents, right? So information asymmetry in this context that is described in the books is that people at the very top would know everything. Like, they have access to all the information, right? Like people like Josaro Cabello, like they have access to know everything, anything that they want to know. But people at the very bottom, like the people driving the Uber cars with the espionage machine installed, they don't know. And they know they are following instructions from an app, but they don't know why or what is the objective of what they're going to do to that person, right? Like, what the organization is going to do to that person. And this is something that they need to do to manage the agents, because if the agents, for example, right, there's been occasions in which they've used this Uber-like app to try to harm me, right? And this is documented in the books. And I don't want to go into details here about what they've done, but they have used that technology to try to harm me. The people driving the cars, some of them don't know that that's the goal, right? They're just following the instructions that the app tells them, like turn left, turn right, drive at 20 miles per hour. But they don't know that the ultimate objective of that they're participating in a scheme to hurt another human being, right? But some others that are also driving cars, they do know, right? They do know that what is the goal, right? So information asymmetry is necessary for them because if, for example, right, if the lower level, right, so somebody who is at the bottom of the society that is driving the car, I'm just going to give you an example, right, to illustrate why this is necessary. If that person, right, that maybe is getting paid, I don't know, a low salary, right, or low fee for driving that car around, because he's not really a high-level agent, right? If that person knew what they were participating in for that low payment, they would probably not do it, right? So they can't allow, because if they see liability to, personal liability, legal liability, they might, run on the other direction, right? So they can let the agents know everything, right? So they have this structure of asymmetry. I'm mentioning this because in light of the last demo, where we talked about structures of control and how monopolies and monopolic platforms, right? Technology platforms that operate globally on markets that are heavily concentrated towards one or two providers. Right? We talked about how those platforms lead to control of the individuals around the globe, right, around the planet. And I was thinking about that, and I understood something. I understood the underlying reason for that. I mean, I understood why is that monopolic control leads to control of the individuals, right? And after I saw it, it's obvious, right? But I did not understand it before, so I want to share that. I think the reason is because that globalization of technology, especially when concentrated in a handful of providers, like the examples we saw before, right? Like the ride-sharing apps, or the medical content platforms, or the mapping applications, or the online payments platforms, right? Like all those examples, in reality, what they create is information asymmetry. That's why they are means of control. Why? Well, because think about it, right? The Communist Party of China, by controlling, for just an example, right? By controlling all the online payments simultaneously, which is a monopoly, really, undeclared monopoly, but beyond the implications of that being a monopoly, the economic and all those implications, beyond that, the more serious implication is that it creates information asymmetry compared to all the other governments. For example, if you compare the amount of information that the Communist Party of China may have about all the financial transactions around the world via their control of these companies, that amount of knowledge about the financial transactions dwarfs the content, the knowledge that any individual government of any country could have about the same transactions. Why? Because they have information about all the transactions, right, around the world that happen in every single country, while individual governments only have visibility about the transactions that happen within their borders, or within the nationals of their countries, or within the accounts that are registered in their countries. You see, it's a subset. So every country can only see a subset, but the Communist Party of China can see all the subsets together. So that is information asymmetry, right? And that is why it's a mean of control. They have more information, right? And by them having more information, they have an advantage. And that leads to control. So I was able to understand the underlying mechanism I think, right? But that's the theory, but I think that's the underlying mechanism. And that's the reason why intelligence agencies are so deeply embedded into this network, because information asymmetry. I mean, that's the principle of operation of all the intelligence agencies, right? Regardless of which country you're working for, whatever you do is based on information asymmetry, right? Like, for example, I don't know, and you would see this like in the news, right? Like when the FBI does an operation, right? Like they have an agent that is undercover, deep undercover for a year, right? And then surprise, we are the FBI, right? That's that's information asymmetry, right? Like they knew that what was going on, and the other people that were doing it didn't know, right? Um, so I guess, right, what I'm trying to say is that you see the traits of the thing on the designers of the thing, right? So that, I don't know, it was a super interesting, um, to me, right? That I'm thinking about these things. It was a super interesting observation, right? To see that. Um, so let me go back to. So we talked about asymmetry, right? Now the next small point. So these are like high level items, right? That I want to not so much discuss or dissect, but like to bring up in this demo. So the other one is about individual liability, right? And this is another concept that I've seen, that I've learned through the years that I've been in this conflict with the Communist Party of China. And I mean, I've learned it in the way they operationalize it to achieve their goals. But after I've learned it, I learned how to apply it to counter them, right? And the idea is that in this group dynamics, right, and this has more to do with group psychology, right? I think this is something that should be examined or studied by people that know about this, right? I'm not a psychologist, like I don't know any about this topic, right? I have only vague ideas, right? But what I've observed is that, and I'm telling you this as a witness, right? Not as an expert. It's not an opinion, it's an observation from a witness. What I've observed is that when they're behaving, right, when they're doing anything that they're doing, whatever it is, right, that might be illegal, right, and to different degrees, right? So there's different degrees of criminal behavior in this, right? Like ranging from surveilling somebody, which is illegal, right? Like if you don't have a subpoena, if you don't work for law enforcement, you shouldn't be following around people and reporting to Diosdado Cabello what they're doing, right? Even if you're doing that using an app that you don't know what it's exactly doing, right? But you know that you're stalking this person or following them, right? Everywhere they go. So it ranges from that, right? To it could be physically harming the person or their child, right? So it could be anything, right? There's a wide range of activities in here, right? But whatever it is that they do, when they do it as a group, then they behave as if there's no consequence. Like there's no limits, right? Like they would do anything, right? As long as it is a group. And I think it's because the group dynamic dilutes the responsibility, the personal liability, right? But the moment they see personal liability, their behavior changes immediately, right? Like that. That's why, for example, to give an idea, right? The moment I documented in the filings the confession of Troy Pickett when he filed that document on November 7, confessing to the fraud against the two courts, he stopped talking, right? He shut up. Like he didn't file a document after that. I mean, any substantive document. Like he filed like a response to the discovery request that I made to Morgan Heimer, which is interesting, right? Because I made the discovery request to Morgan Heimer and I served her. I never served him with that, but he then yesterday filed a response to that to try to free Morgan Heimer, so she wasn't in default, right? That was his goal, because she's in default with that discovery. But the service was improper because they had set a deadline in the order for the proceedings, quote unquote, that was at noon on the 1st of December. And he served that document at 5 p.m. on the 1st, so 5 hours after the deadline. So the service is invalid, therefore Morgan Heimer is still on default. Therefore, she cannot leave the case, right? So, but but that's not a substantive filing, right? But the filings that he does, where he says, yes, this is the order, and you have to pay rent and those things, he hasn't said anything, right? To not further incriminate himself, because he sees personal liability. See, but when he was acting, in cahoots with Morgan Hagner and with the others, and they were acting as a group, and there wasn't a clear responsible. He was very verbal, right? Like he was very, I don't want to say verbal because it was in writing, right? But he was very expressive, let's say, right? About his legal position and all that regarding the case and the orders. But that's just an example, right? So when they see personal liability, they act. When they don't see personal liability, when they see personal liability, they act to reduce it, right? To reduce the liability. But when they don't see personal liability, they act to further the network interest, regardless of how criminal the thing that they're doing or not doing, right? Because the lack of action also sometimes is a way to support the network, right? To cover up or to help the scheme, right? But depending on the level of liability that they see, they adapt their behavior, right? And I've learned this. I've learned about the concept of liability from my mentor Gates, but in a different context. And this is also described in the book. It's about how they gather intelligence via, the agents. They have different roles, right? Like, and I've described this in the book. So it's different roles that they fulfill depending, on the relationship to the target. One of the roles is feedback gathering agent, right? So the agent will expose the target to a situation to be able to record with the phone or with the microphones that he or she might be wearing the reaction of the target to see if the reaction is negative, right? So if the target shows aversion to the situation. Why? Well, because the network wants to know what hurts psychologically the target, to then amplify it and do it, 10 times amplified to induce psychological stress, right? But that is nothing more than gathering intelligence to understand the psyche of the target and to do kind of liability analysis, like what is that the target fears, right? That in a way, like what you fear is what you see as a liability to you, right? So once they understand that, they attack the target with that, right? So I understand the concept, and then I started applying it to them, right? That's why I created. I don't know. There's a project I worked on that is documented in the book that I call the Circle of Transparency. I invite you to read that. It's a very interesting, I would say, right? To me, it was a very interesting project to work on. But it's nothing more than doing liability analysis based on what you gather, what you understand from the adversary. And your goal should be I don't want to say maximize. Sometimes it's not about maximizing the liability, but about spreading it. Okay? So everybody's liable. Because think about it, right? Let me give you an example, right? Concrete example. Troy Pickett confesses to the fraud on November 7 in writing, right? I have direct evidence. So I could dedicate my energy into, pursuing that, right? And trying to expose Pickett at the highest, in all the possible ways that I could, and contacting journalists and the bar and, the FBI. And yeah, I could do that, targeting Pickett, right? Because he has confessed. But if I do that, I would only break one link in the chain, right? So I could choose to devote my energy on that, or I could choose to devote my energy into spreading that liability across other actors, right? So they also see liability, and they stop behaving as a group of individuals and start behaving as individuals, right? In which case they see liability, and then they stop doing the thing that would further the agenda of the network. So all this to introduce this topic of how I'm applying Of course, I'm not going to really reveal at this point my whole strategy, but um, I think it's important to document this. I'm going to give some level of detail, right, about the strategy and how I developed it using information retrieval techniques. So this is based on information retrieval techniques that I've learned at Google working in search ranking. And I did not invent this. I learned this from my colleagues at Google. And what I'm going to describe is a process very similar to the way a ranking engineer works in a information retrieval system that could be a search engine, could be an email client, could be uh, a distributed system of the FBI, right? It could be anything. These are generic information retrieval techniques that allow you to model problems and solve them at a scale, right? Which is what the network does. And that's why this thing is a weapon, because it's a way to generalize something at planet scale. So I'm going to go back to my slides, right? So the first 4 slides we went through in the last session, and I created another 4 slides for this session, right? So I'm going to start with this one. Let me see if I can put it in a way that it looks better. Maybe this? No. Let me see if I can. Well, okay, I'll try to maybe increase the zoom. Okay. Oh, this is interesting. I'm going to click on this to see what it does, just to try. It's a generative. I don't know. I'm just curious. Let me see what it does. Well, what it does, I'm going to start, showing you this. So this is really, it's a network analysis, right? Chart. It's a directed graph, the same as we use at Google to represent things and to represent problems. And what this chart is representing, what this directed graph is representing, is the different chords that I've, oh, this is interesting. Oh, I like it. Okay, let's see. Let's try this one. Okay, so it's yeah, it's interesting. Wow. So the chart, the graphs, the directed graph represents the different chords. Okay. And the arrows that you see going from one chart to another, what they represent is that chord, the one where the arrow is coming from, is aware of a recourse or a relief, a recourse that I thought on that other chord, the chord where the arrow is pointing to, or a relief that I thought on that other chord, right? So that means that chord A is aware of something that I did on chord B that could have been directed at chord A, at its own chord, or at the wire fraud that Troy Pickett confessed to, right? And this is important because wire fraud is a very serious crime. And if a court is aware that Troy Pickett that Troy Pickett allegedly committed this wire fraud, I mean, they have to take a position, right? Like not acting. If you are an officer of a court that is, tasked with, upholding the law, and you see these allegations and you don't do anything, I mean, it will raise questions, right? So, you have to take a position. But so the level of awareness. So if you zoom the arrows of it, and this is kind of a measurement of, if you want to put it, map it to a concept, right? In science, it would be like measuring entropy, right? If you count the number of arrows going out, or exactly going out from a chord, because it means that the court is aware, right? So if you count the number of arrows, if you sum them up, that is a proxy for, let's call it's a metric, right? So what I'm doing is defining a metric, something that I can translate to a number. And the idea on these techniques of information retrieval is to, encode observations or things that you can observe in a vast number of things in the corpus. The corpus here is the courts, right? The set of courts. So these arrows are something that I can count and transform into a number. Right? So the technique is you define metrics that are numeric metrics, right? And then you try to represent the world or the behavior or the mechanics, the underlying mechanics, using a mathematical formula using those numbers. That's the entire workflow. And then you do experiments, right? So you changing the formula, right? And see how it changes the ranking of the results. And that, will let you see things, or will let you come up with an algorithm to really understand the phenomena, right? And this is the entire workflow of a ranking engineer or an information retrieval engineer at Google and in any other company, right? That does this at that level. So this is what it is, right? So I'm going to switch back to the blank, so without the beautification of the slide, because I don't want to distract you with the colors, right? So this is what the so let's walk through the courts, right? So all this started with the 387s, right? So the 387 court is aware, officially aware, right? This is the key. This is an important keyword, because I think many of these players are aware, because like they are getting information by unofficial channels, and I know that because the Venezuelan informant told me, right? Like I know exactly who's getting information. Of course, I'm not going to reveal that because I'm not going to show my hand, but I can tell you, right? I know that some of these players are actively receiving information from the network, information that is coming from the Communist Party of China, right? There's no other way to put it. Which is it's a serious thing, right? Like that an officer of a court is receiving information from a foreign entity to make a decision. Anyhow. So, the 387, for example, right, is aware that I filed a motion to recuse and that it was reviewed by the two motions to recuse, really, one in July and one in October. And both were reviewed by the 11th Administrative Judicial District, right? So Judge Brown, who was appointed by Governor Abbott. So that creates one arrow. Well, this is a design choice, right? Here, see, I'm choosing to represent it as unique awareness, right? So even though it was two motions to recuse, I'm only putting one arrow, right? But a better way, but I didn't want to do this because it would make the diagram more complicated. But a better way would be to put two arrows here, one for each motion to recuse, giving this section 2 points instead of one, right? In the numeric metric that I'm trying to derive from these mechanics. But let's keep it simple. Let's keep it unique, right? So it's only one arrow, regardless of how many instances of awareness there were of an instrument being filed on court B and the court A being aware of that. So because I also filed the petition for writ of mandamus, two petitions for writ of mandamus with the first appellate court, then it means that the 387 court is aware of that filing, right? Because they received documents from that, and because I also filed a copy of the petitions with the 387s, and I served them, right? So they are aware. So again, but because we're doing the unique awareness, we're going to only put one arrow and count 1 point. So far we have two arrows for the 387 code, right? And they are also aware that I filed several things with the federal court, the Southern District of Texas, and because of that, they get one arrow in that direction, right? So it's 3 arrows. So you see the 387, but they're, oh, yes. So 1, 2, 3. There's one arrow missing here, right? So they're also aware that I filed with the Supreme Court because they got the postcard. The Supreme Court sent them a postcard yesterday notifying them that I filed. I didn't tell them that I filed, right? But the Supreme Court told them. formally, right? So now they have another arrow going here, right? So I have to correct this, the 387 from being 3 to being 4. So they have 4 in the awareness score, right? So you see what I'm doing? I'm translating these observations into numbers that I can then use to compute formulas that I design. And then I'm going to test different variations of these formulas, right? To understand, different ways of modeling at the end, right? My end goal with this is to model the liability, the individual liability of the officers of those courts by acting or by not acting, right? Because either way, if fraud is being committed and they know, because it's one thing to say, it's one thing that, there's an allegation of serious fraud being committed by Troy Pickett, Morgan Heibner, and William Kyle Adams and the Adams law firm together in concert. And it is one thing that you are another court and that you heard this from one place, right? You could say, well, this is I discounted it, right? I didn't think it was that serious, right? But if you're hearing this, that this has been brought up to 3 or 4 other courts, you discounted it 4 times, right? In all these different avenues, you didn't take it seriously. I think it elevates, right? The thinking of modeling the liability using partially this metric is because the more aware you are of the violation and the crimes, really, if you don't act, it makes you more liable, right? Or I don't know if more liable, but it would be easier to demonstrate that you didn't act when you should have acted, right? Yeah, it would make you more liable to negligence, I would say, right? Not necessarily, it doesn't prove that you participated on the scheme, but you were negligent, right? Like if you heard this from 4 different courts and you didn't take a position, right? Of course, there's also other questions, right? From a legal point of view, jurisdiction, expertise, right? A court could say, well, it's not my area of expertise, I didn't know, right? For example, the 387, being a family court, could say, well, we don't see any cases about wire fraud, we weren't sure, right? But the federal court cannot say that because it's a federal crime, right? If they see these allegations about wire fraud in black and white, showing, why this is wire fraud, and they don't act, it's a different game, right? Because they are a federal court that should know the federal law, right? Even if it's criminal and they're a civil court, right? Even if it's a federal criminal law issue, and they are a federal civil court, right? But still, they should know that this is wire fraud, right? But so that's the idea behind encoding awareness in this, right? Because it elevates the probability of being liable, right? I don't want to say that elevates the liability, but elevates the probability of being liable, right? So I built this chart with. I'm not going to repeat all the process for all the courts, but believe me that these arrows represent awareness, right? Each arrow represents that court is aware of something serious that I filed in that other court regarding the fraud committed by this group of individuals. So and I put those metrics, those numbers of that metric in this table, right? In the first column here that says awareness score. I'm going to reduce the size of this so it fits. Okay. Okay. Now there's a second metric, right, that I came up with, which I'm going to call it. I'm going to qualify this comment in a second, right? But for now, I'm going to call it judiciary power. Okay. And for this first pass, we're going to think that the judiciary, and this is an arbitrary definition that I'm making up this metric, right? As a software, as a ranking engineer, you can, and I'm talking to the kids, right? I'm talking to the kids that are going to be the engineers of this in the future. That are going to work on this area, right, of knowledge in the future. When you're working as a ranking engineer, you have the freedom to make up your own metrics, right? You're not bound to the metrics that other people define. You can make up your own metrics, right? And this is the beauty of this work, that you can be creative. You can create metrics that maybe nobody thought of before, right? So I'm going to get creative here, and I create this metric called judiciary power. And the definition of this metric for now is going to be, for now, right? I'm going to change this in a minute, but For now, it's going to be how much power that court has in terms of, for example, right? I don't know how to define it in English really, but what I'm trying to represent with this metric is, can this court fix the problem, right? Can this court override the decisions of other courts? And if so, of how many courts? Like, so for example, the 387th has a score of 1 in this arbitrary metric I'm creating. Why? Because they cannot override the decisions of anybody, or they can only control their own decision, right? They cannot tell Judge Brown what to do. They cannot tell the First Appellate Court and Justice Adams what to do. They cannot tell the Supreme Court of Texas what to do. And they cannot tell the federal court what to do. So they have a score of 1. Judge Brown, on the other hand, has a score of 2 because she can control her own decisions and she can override the decisions of Judge Telfer and the 387th, right? So she has some power over another court. So that gives her a score of 2. The First Court of Appeal, in this context specifically, has a score of 3 because they have power over their own decisions. Chief Justice Adams can influence the panel that he's working with and can sway those decisions, right? And he can also, if that panel makes a decision that fixes the problem, he could override or order Judge Brown to fix what she didn't do, right? What she dismissed procedurally. They can force her. They have jurisdiction over that. And they can also force the 387th court to take an action. Right? So they have a judiciary power according to this metric of 3. By the same principle, the Supreme Court of Texas have a judiciary power of 4 because they can order things to all these other 3 courts that I've mentioned. And the federal court has a judiciary power of 5 because they can control their own decisions and they can order all these other 4 courts what to do because they're the federal court. They can order, even they can overturn or do things even if the Supreme Court of Texas, because the separation between federal government and state government. Now I have to say I'm aware that there is a doctrine that says that federal court tries to not step on the state law grounds, right? Like to keep separation between federal and state, and I understand that. But, and this is an important thing, that doesn't apply if the federal crime is being committed, right? If there is a federal offense or something that touches on like for example, violating civil rights under the color of a state law, that's something that a federal court can intervene, right, and should intervene on that area, right, specifically. I mean, they cannot decide on a divorce case, but they can void an order that is violating civil rights under the color of a state law. So they have the power to intervene, even if the Supreme Court doesn't act, right? And especially if the Supreme Court doesn't act. So that gives them a score of 5, right? In this judiciary power metric, right? Now, I came up with another metric, right? Another metric that is, and I define this metric as how many motions are either pending before each court, or, well, you can start by counting how many motions were decided on, right? Or how many instruments, right, were decided on that were filed by me, right? Because I'm the person that is being affected by this, right? Me and the child. So I'm not talking about the motions filed by the other party, right? By Morgan Hagner and Troy Pickett, and those motions get processed, no problem. The problem is my motions, right? So you can start by counting the motions that have not been ruled on or that were dismissed procedurally, because that's the TTP that the NORUL uses, right? Like they dismiss things based on technicality. I'm gonna give you an interesting example in a second. So how many motions are not ruled on, right? But the interesting part of that statement or of that definition of a metric is really it's not how many have been ruled on, is the opposite. It's how many have not been ruled on. That's the interesting part, right? Because that inaction that lack of action, right? Lack of substantive or lack of action on the substantive matters, right? That is what is a tell, right? That there might be design, right? So if you count that, this arbitrary metric that I define is how many of my motions are either pending, right, regardless of the time they have been pending for. Well, not regardless. Let's say that they have been pending for an unreasonable time, right, more than 2 weeks, right. And out of those, or also combined with those, how many have been dismissed by procedural technicalities, right? That don't allow the substantive matter to come to the table. If you sum those two numbers, that is this metric, right, that I'm talking about. And the idea is the higher this number is, the more likely. What I'm trying to create is a numeric metric that by proxy tells this formula that I'm going to come up with in a second, how biased could this court potentially be, right? And this is a metric, right? It's just a metric, right? It's not an accusation. It's just a metric that signals that this could be the case. There might be other explanations, right? It could be that I'm a litigant that they don't understand what I write, right? And then therefore they don't take an action, right? It's possible. I mean, I'm not going to say that it's not possible. It could be an explanation, and that's the narrative that Troy Pickett wants to build up on, right? And that's why they did that thing where they sent that deceptive notice of proceeding, right? I'm going to also talk about that in a second. It's a way to build up that narrative, right? To explain, because they think they're going to be able to talk their way out of it and say to federal authorities that is not that what I'm saying is not true. Is that the judge didn't rule in any of my motions because I'm a person that it's impossible to understand what I'm writing. Right? I'm a crazy person. Right? But anyhow, that's the metric, right? So now I'm going to come up with a formula, right? And the idea here is that you model the problem, you model your observation, you try to model it with a mathematical formula. And when I say this, you may be intimidated by thinking, oh, this is math and it has to be a complicated formula with a lot of, sines and cosines. And no, like it could be a formula as simple as a multiplication and a sum, or just a multiplication or just a sum. Like it doesn't have to be a super complicated formula, right? But something that what you want to do here is to try to capture the spirit of this, right? So what I'm trying to do, my end goal is to try to sort this courts to understand which one is the one that has the highest, I don't want to say liability, but the highest probability of being found liable, right? Legally speaking. So to understand which are the weak links, the ones at the top in this distribution when I sort the courts, those are the ones that I could choose to focus on. For example, right, if I wanted to break them, right? Or the other approach is what I was saying before, distributing the liability, right? What if I look at the tail of the distribution and I see a court that doesn't have a lot of liability or probability of being found liable, I have to concentrate on how to create evidence. I'm not saying fabricate, but how to get evidence into the record that increases the probability of being found liable, right? So they don't become a strong link, right? So I want to prevent that any of these courts could be a strong link which could be exploited, right? By the network and by using them as a stronghold, right? So you see, this is liability analysis using information retrieval techniques. So for example, right, in this mathematical formula that I'm going to propose is simple. I'm going to multiply this first version, right? So actually I did several iterations. I think this was V7, if I recall correctly. What I'm going to tell you right now is V7. So the formula is here, right? So I'm proposing this formula, right? Awareness multiplied by power, and that product, the result of that, I sum to that the number of pending or summarily dismissed motions, like motions that were dismissed by procedural technicalities, like that were not the substantive matter was never addressed. So if we review the numbers, right? The 387 has something like 40 of these motions, 40. So I filed 40 over the last 7 months, 40 motions. And out of those, none of them were addressed or ruled on by the judge for 7 months. Until now, the judge has never ruled in even one of my motions, right, in the 387. So that makes it that this metric has a value of 40, right? On the 11th administrative, I filed 2 motions to recuse on the 37th that went there. So Judge Brown, who was appointed by Governor Greg Abbott, and in both cases, she dismissed the motions to recuse procedurally, right? Citing a procedural rule, she didn't address the grave allegations contained in those motions. So that gives that court a score of 2 in this metric. The same with the first Court of Appeals. The first petition for writ of mandamus was dismissed based on a false premise presented to that court by a fraudulent document filed by the Adams law firm. And then Chief Justice Adams, note the name Adams in both the who filed the fraudulent document and the Chief Justice that led the panel, that panel dismissed the petition based on a fraudulent title in that document filed on October 10th, 2025. Index 62, I think. Let's make this proper. Let's review. The actual index. I think it's 62. Yes, this document. See, let's say notice of entry, temporary orders, which in reality was a notice of hearing, but they titled it that way to trick the appellate court. So the appellate court could dismiss the petition for writ of mandamus the first time. Okay. Yes, I want to make a note, right? Like note. So today at this point, right, is December 2nd, 2025, and it's 8:53 p.m. Central Time. And note that the last index in the docket today at this point is 127, and that the judge hasn't ruled on the supposed proceedings that Morgan Heibner and Troy Pickett are pushing for to get Morgan Heibner and the Adams law firm off the case, right, to cover up the crime. This is important for something I'm going to say in a few minutes, but I'm saying this in case, because, like this has happened before, right? That when I say something, they go and change the docket. But I want to record here, and you can see clearly here that at 8:54 p.m., nothing has been entered into this docket, right? Regarding those proceedings that were supposedly taking place today, October the 2nd at 9 a.m. And I'm going to talk more about that in a second. But again, right, so the first Court of Appeal dismissed that petition of writ of mandamus, and then the second petition of writ of mandamus directed at Judge Brown was dismissed by want of jurisdiction, which that's an atrocity, but they can do whatever they want, right? So, but this is also a technicality, right? They didn't address the serious allegations contained in the petition that included that Troy Pickett and Morgan Heibner and the Adams law firm committed fraud against a panel led by Justice Adams. They didn't touch any of those allegations. Right? They just dismissed the procedure. So this gives the first Court of Appeal a score of 2 in this metric, right? 2 motions dismissed procedurally. The Supreme Court of Texas, I don't have information because I just filed this on last week, Friday, I think it was. No, I filed this on the 25th of November. So it's been almost a week, right? So it's too early to tell. So I'm going to give it a 0 on this metric, right? And the federal court, I filed so far 7 motions in split among the 2 cases, and only 1 was ruled on, which was an emergency motion for a temporary restraining order when the tire situation happened, and it was denied, right? So, if it's denied, I'm not going to count it, right, as a negative signal, because, I could make a filing that doesn't have legal merit, right? They have the right to deny it, right? That's not a problem. The problem is if they don't rule on the motion for a long period of time, or if they ignore it, right? Or if they dismiss it procedurally, right? To not touch on what I'm saying, right? Because that's a way to deny due process. So, out of the 7 that I filed, only 1 has been ruled on. So this gives this court, the federal court, a score of 6, because there's 6 motions that are still pending, right? That haven't been ruled on. So, in this metric, in this total score, in this, ranking score V7 I'm proposing here, I'm saying our awareness multiplied by judiciary power plus the number of pending motions. So this is my mathematical formula to try to model these dynamics, right? And then, in this column, I basically compute the number, right? So 4 multiplied by 5 is 20, plus 6 from here are 26, right? So the score of this court in this metric, in this scoring system would be 26. And the idea is to sort them by decreasing score. So you get the ones that have the highest score at the top and the ones with the lowest score at the bottom. So I didn't do the sorting. I'll do the sorting in a second, right? But so this gets 26 using the same computation technique. 3 multiplied by 4 is 12, and 2 multiplied by 3 is 6, and you have to add 2 for the two motions dismissed procedurally. That gives a score of 8. And you do the same with the 11th administrative court, it gives a score of 6. So you see, the one with the highest score here is the 387, and it's coming mostly from the ignore motions, the 40 ignore motions for 7 months, right? So I'm going to move this to another row in the top. Right. So according to this ranking system that I'm describing here, the score with the highest score would be the 37th, right? So that's the one that is more likely to be found liable, right? According to this ranking system. Followed by the federal court. So, but this is because, look, the number of motions in the federal court is not that big, but is the court with the highest judiciary power by this arbitrary definition of judiciary power that I said. Okay. So like the way you model or that you express that formula, right, has to have a correlation with your interpretation of the world, right? And this is what I find fascinating about this area, right? That in a way it marries simple math, really, right, and signal analysis with reality, right? So it's a very tangible area of a study. So you see, right? You can see in this distribution, right? 43. So the scores would be 43. Let me make them bold and red. The scores would be 43 for the 37, 26 for the federal court, 12, 8 for the First Court of Appeals, and 6 for the 11th administrative. So this is beautiful. This is interesting, right? Because, well, you see, the First Court of Appeals and the 11th administrative court both fell, according to this, math and metrics, both fell at the bottom, right? So it means that they're the less likely among. I'm not saying that they're not likely to be found liable, right? But among this set of 4 courts, they're the less likely to be found liable. Like there's, and like I see this, right, and I see that it correlates with a couple of things, right? It correlates with where they fall in the judiciary system, because these 2 courts are in a way shielded. Why? Well, because to get a filing, if you as a citizen, right, to file something with this on these courts, you have to be subjected to something unfair on a lower court first. Like not every citizen can go and file in the First Court of Appeals. You have to be a citizen that receives a negative judgment, right, on a lower court. So this restricts the population that can actually file something in these courts. And because one of the metrics is, awareness, that shields them in a way. But this is interesting because this happened to be the two courts where the justices, the presiding judges, have been appointed by Governor Abbott. Right? So it's an interesting thing. I mean, that the two could be a coincidence, right? But that the two with the least level of exposures are the ones that were appointed by Governor Abbott. It's interesting, right? Yes. So, like going back to the analysis, I could choose to do multiple things, right? So I could choose, me analyzing what I could do right here in this situation, right? I could choose to, to focus on the 387s because they're more likely to be found liable. Or I could choose to spread liability to the ones that are least exposed, right? Like, for example, to give an idea how I could do this, right? I could go to federal court and file a notice that puts in the record the decision of Judge Brown and the information I gave her that she made that decision based on, right? That would increase her level of exposure, right? Or I could do the same with, so I have ways that I could introduce things in the records in other courts that would increase the liability, right? Or the likeliness of being found liable, right? So now I'm going to do the same, right? So this is awareness. Okay, so this is kind of a side note, right? So in the previous slide, I said judiciary power, right? On this column, right? And I said, well, I'm going to tweak that in a second. Let me delete this so it gets out of the way. So this is the same slide we had before, right? But I want to say that judiciary power, sorry, this one, right? Yes. Yes, so here you see, right? The 387 is on top and then the other four. So judiciary power is based on whether they can override decisions or make another court do something, right? But I also had another version. No, sorry. Let me not confuse you because there's two variants I want to show you, right? So one variant is this is another ranking idea, right? And the idea is to see the world from different angles, right? If you change the formula or you change the metric, the definition of one of the variables in the formula, then what you're doing really is changing your point of view, right? You're seeing the same problem, but from a different angle, just by changing the definition of a metric or the formula itself. So I'm going to start by changing, in this one, I'm changing the formula, right? So in this one, I'm not adding the number of motions that are ignored or dismissed procedurally. I'm just focusing on the judiciary power, right? And the awareness. So if you do this and you sort them, then the one that ends at the top is the federal court, mostly because of the judiciary power they have, that they can override anybody, right? So this is also an interesting observation, right? This, for example, this view of the world shows me what is the ultimate solution to the problem, right? The ultimate solution is a federal solution. And I've known this for months, right? I documented it in the demo and in another book. In one of the books, I mean. So this problem has a federal solution, right? The solution to this is federal, it's not a state, right? And then at this point, it's obvious why, right? Like all the roads are taken on the state area, right, of the law. So this is an example of how you can change the formula, right? Now I'm going to show you an example of how you can change a metric, right? So now instead of saying judiciary power, I'm going to say coercive power, right? And this is an interesting difference, right? Because one thing is to have judiciary power, that you be in a court, you can override other courts, right? But it's a different thing having coercive power. What is the difference? Well, coercive power means that the court has the power to affect your life as a citizen, right? For example, in my case, the 387 took my parental rights away, right? whatever happened, like let's not get into the details on how they did it, right? Or what happened, or who committed the fraud. Like, all those things aside, they took my parental rights twice, right? The first time in April without me even knowing, when they signed that secret temporary order that Morgan Heibner and Troy Pickett, ultimately, right, really behind the scenes, sent to Tesla, right, to justify taking the car and all that. So that's the first time they took my parental rights. And the second time was when, they signed that order on October 15th after the motion to recuse was filed, and the court had no jurisdiction to sign anything, right? And they signed that order that was fraudulent, that had timestamps that was never even, served as a filed order, as a signed order. It was never served to me as a signed order. So, the 387, in terms of power, it has more coercive power because it's the only court among the 5 courts that can take my child, right? So, in order to coerce me, like, that's the court that is more powerful than the others, right? Then, so I gave them a score of 5, right? Because of the coercive power they have. Then the First Court of Appeals. Why? Because they have the power to coerce me via shielding judges from lower courts, like Judge Brown, who was appointed by Governor Abbott, and the 387th. So I gave them a score of coercive power 4. The 11th administrative, I gave them a score of 3 because they have the power to shield the 387th, who can take my child, right? Who can take my parental rights away. And they've done it twice. So, they get 3 points. And the federal court has a coercive power of 1 because they cannot really do anything serious to me. The most they can do is, I don't know, they threaten me with a motion for sanctions in one of the dockets because of excessive filing, quote unquote, right? So the clerk put in the docket that I was filing too many documents and threatened me with sanctions for filing. Imagine that, right? But that's the most they can do, right? They cannot take my the counter. They cannot take my child, right? So the most they can do is impose sanctions, right? But so their coercive power is only 1. And the same with the Supreme Court of Texas. The most they can do is dismiss my petition, right? But they can't really, they cannot take the child of a citizen. All they can do is ignore what the citizen is asking them to do, right? So you see, you change this metric, you apply the same formula that you had B7 or whatever, right? And this gives you a completely new view of the world, of this world, right? What this tells me is if I wanted to take a protective, a defensive stance from a legal point of view, the ones that I have to defend against is the 387th, obviously, right? The one that can harm me and can coerce me is the 387th, not the others, right? So you see, depending on what is the problem you're trying to solve, you can tweak your formula or your metrics, right? Yes. So now this, of course, shows the opening, right? So the opening, as I said before, right? Like this is, and you can see it here, right? That this is something. Yes, awareness by judiciary power. So this is something that has a federal solution, right? And that's the opening, right? So the opening that the pipeline flags, and this, I'm not going to take credit for something that I use software to see, right? The pipeline flag that there was an opening, right? The opening was that if you see this, right? So in the pipeline, right? I keep these metrics. The pipeline has hundreds of different metrics, right? And it picks and chooses and basically does hyperparameter tuning on those metrics. And as you see this metric that I have here on this slide that says how many motions are pending or ignored. The pipeline has an equivalent metric, but for the opponents, for Morgan Heibner, right? Which is, of course, the metric is beautiful for them. Like all their motions get processed and ruled on immediately, right? So the pipeline, the opening, the pipeline flag is, I'm gonna try to translate the debug, right? the engineering debug into actionable intelligence, right? So the pipeline flagged that the opening was, and this is why I acted on this today. The pipeline flagged last night that the opening was that precisely that thing that they think is a strength was a weakness, right? And was a mistake they made. So what happened was on October 28th, Morgan Heibner filed a document that they titled it was an order from the court. In fact, let's look it at the document. Right, it's October 28th, I think. Yes, this one. So index 102, right? And it says court proceedings. It says court proceeding on the motion for withdrawal of counsel via submission. And this document is very interesting. I'm not going to open it here to not waste time, but this document, I don't know if I have it. Maybe I should show it to you. Let me see if I have it here in the bucket. No, I don't have it in the bucket, but I'll put it in the bucket. But it's index 102, right? So this is a document that says, if you read the title, right, it says court proceeding on the motion for withdrawal of counsel dash via submission. So this is saying that there's not going to be a hearing, that this is going to be done by submission. And in that document, I wish I had it. Let me see. It's probably because they mark all their documents as private, right? So nobody can download them. This is intentional, of course. I'm gonna see. Maybe they made a mistake, and let me download it here. No, they did not make that mistake. Okay, but I'll post it in the bucket. But I'll tell you the story, right? So this document 102, right? So it says that in this title of the clerk, right? It says court proceeding on the motion for withdrawal of counsel. Now the document on itself, the title, it doesn't say via submission, right? It says only court proceeding on the motion for withdrawal of counsel. And then within the body of the document, it says that it's going to be done by submission in a small sentence, right? But then immediately it says that, the first thing it says is that the proceeding is going to take place at 9 a.m. on October 2nd. And then it says that it has a small note that says no party should appear in person, right? But it says that within the first paragraph. And then immediately after that, it says that the witnesses should be submitted, the witness list should be submitted before noon on the previous day, so on October 1st, yesterday, right? Before noon. And that the exhibits and the exhibit list should be submitted before noon on the previous day, on December 1st. So this is intentionally very confusing because the title doesn't say via submission. It just says that in a small phrase on the first paragraph. And everything else that this order says implies that there's going to be a hearing because it's giving a date, a time, and it's asking for witnesses, right? If it's a submission, how are these witnesses going to tell anything to the judge? I mean, they wouldn't be witnesses. They would submit affidavits, right? If it's via submission. So this thing is intentionally made in this way to mislead a pro se litigant, right? And the goal with this is to make me think that there's going to be a hearing, so I object to the hearing. They ignore intentionally my motions, right? And then when this comes to head and authorities confront them or interrogate them or interview them, I don't know what was the word for that, they're going to say that I'm a difficult litigant, right? That I don't understand the law, and that, for example, and they're going to point at this, right? They're just fabricating something to point at to justify the unjustifiable. So they're going to say that, look at this, like, there is we sent him an order that is clearly marked in the docket saying that it's going to be by submission, and he spent 3 motions complaining about a hearing that was never going to happen. Like, this is a crazy person, like the person that doesn't understand the law and is making claims that have no grounds, right? So this is a way to fabricate a defense, right, in the future, by creating confusion on a process litigant using this deceptive technique, right? Because the document is deceptive. And the clerk is in it because the clerk put that note via submission, right? So the clerk, this means the clerk read the document and she focused her attention on the one small sentence that said via submission, but she did not see that it had a time, a date, and asking for witnesses, right? And witness lists. She chose to see it in that way, right? In a way that would create this narrative, right? That they want to use, because they think they're going to be able to talk their way out of that, right? I mean, of what they have done until this point. So that's interesting, right? Right. So going back to the conversation is that the pipeline sees, right? So the opening that the pipeline saw was that when they filed this document, right, and they set this thing in motion for these supposed proceedings. I'm just explaining why the proceedings are fraudulent. Oh, and I should also say this happened on October 28th, when the court was under an automatic stay. Because if you go up to October 15th, right, you can see that I filed a motion to recuse, right, on the 15th, on index right, index 88, right? Respondent's second verified motion to recuse, right? Which got index 88, which is before the supposed temporary orders, 89, right? And that difference in the index is important because it shows that they signed the order after my motion to recuse had got it, right? They may have changed the order in the docket, but the index, they can't change it. And I got the lower index, right, the 88. So the court did not have jurisdiction to sign that order, right? But because I had filed that motion to recuse on October 15th, and the court was under an automatic stay, the court had no jurisdiction to issue an order for a proceeding on the second. Like this is improper. That notice is improper. And the order itself, ordering that proceeding on the second, it's improper because the court did not have jurisdiction to set that proceeding for the second, right? So even that is improper and should be struck from the record. But anyhow, they set this thing in motion, right? And the opening that the pipeline identified is that all the motions of Morgan Heibner are ruled on, right? They are not ignored. So the play that the pipeline identified, the opening, right, to unlock this, to weaponize their mistake, is to make my arguments in this motion, right? To make my arguments in this motion that Morgan Heibner is pushing for. Morgan Heibner, Troy Pickett, and the Adams law firm in concert. They're pushing for this in concert, and I'll tell you why in a second. I'll tell you why I say in concert. It's not only Morgan Heibner trying to withdraw herself from the case. Troy Pickett is actively helping her because he needs to cover up the crime, right? So the opening is precisely their strength because their motions are always ruled on, are never ignored. So if I make an argument, then that argument, because this motion is going to be ruled on because it's being proposed by Morgan Heibner, the Adams law firm, and Troy Pickett. And because it's going to be ruled on, whatever I say is going to be read. Even if they don't address it, it's going to be assumed that it was read, right? Obviously. So the weakness, I mean, the opening is clear, right? I have to make the allegations that I'm making in this proceeding, right? Because then they don't have a way to ignore it, right? Because the motion is going to be rolled on. Now, if the motion, and this is very, very interesting, right? The pipeline also saw a path. There's a subgraph in which the judge ignores this motion. But that would also I mean, this puts the judge in a bind because he hasn't ever ignored emotion of Morgan Heibner before. All the emotions of Morgan Heibner are processed. So if he suddenly ignores this one, I mean, it's kind of signing a confession, right? Like, so what he would be saying is that it doesn't matter who files the motion. What really matters is if I make an argument in a motion, it gets ignored, right? Because all the motions where I have not made an argument in writing of Morgan, the motions of Morgan Heibner are being ruled on. But because I'm making an argument in writing, that cannot be ignored, right? Because it's a serious accusation of a federal crime, then it's ignored, right? So it creates um, I would say explosive situation. Now the pipeline also, looking at the subgraphs, there was a fork. There was two different things that I could, argue, right? One was that in the same fraudulent order, there is a clause inserted by the Adams law firm saying that whoever presents for enforcement an order that they know it's invalid or no longer in effect commits an offense that is punishable by jail time of up to 2 years and $10,000 in fines. This is said in that order, right? So I could make the argument in response to this that, to ask for sanctions and to ask that the sanctions include the jail time, because they are in contempt of their own supposed order, right? That's one path I can take. The second path is to document the fraud, the wire fraud, right? So the demands for property, so the demands for property and money using electronic communication means and deceptive tactics, right? I'm talking about the email that Morgan Heibner sent me on October 3rd, asking me for making monetary demands based on a document that she knew was fraudulent, right? And the filing of Troy Pickett on November 7th, where he also knowing that it was fraudulent document because he represented 2 different dates to 2 different courts about the signing of those orders. So he knows that fraud was committed, and he seek enforcement of that order, right? And is making explicit demands in that order, demands for money and property. Money and the property being the black Tesla and the passport of the child. So, I could put those, ask for those sanctions and ask them that Morgan Heibner is not relieved from the case until that motion for sanction for that federal crime really is addressed, right? But you see, there's 2 different avenues, right? I could ask for prison time based on their own fraudulent orders as a sanction, right? Or I could ask that the allegations of water fraud are addressed. The 2 things are not recommendable because they fall into different categories of law, right? One is state law, the other one is federal law. And I'm not, if I choose to pursue the wire fraud angle, it's not that I'm asking this judge to enforce federal law, right? But he has to address the allegations, even if it's within the context of the state law. But you see, I'm saying all this because of the analysis of liability that we reviewed before, right? In which we concluded that the solution is federal, right? And you can see this in this chart where we're only taking into account V6. This is a score V6, which is awareness multiplied by judiciary power. Because the solution is clearly federal, I have to push for the federal solution, right? So I decided, and this is human decision. This was a human decision that I made, where I decided I'm not going to mention the request for jail time according to their own order, right? And I'm going to focus on what is something that brings federal liability. Why? Because I'm going to use that in the federal court, right? And the federal court cannot possibly ignore this because this is a federal crime, right? So it's a checkmate situation. If the judge ignores my argument, then he is saying, well, if you have something grave to say, I'm going to ignore it. right? Doesn't matter even if Morgan Heiner files the motion, right? Even though I have always replied to her motions, I'm going to ignore this one. I mean, if he lets Morgan Heiner leave the case, ignoring the grave accusation of wire fraud that I'm making, I mean, it would be negligence, right? At the minimum. And if he doesn't let her leave the case, she's trapped. And the Adams law firm is trapped in a case in which there is another justice with the same last name, Adams, who fell for the fraud of Troy Pickett, right? So any way they do it, they're trapped, right? It's a checkmate situation. It's the second time I'm able to find, using software, a checkmate situation. The first time was when I filed the second motion to recuse, right? But they haven't learned the lesson. They keep getting deeper and deeper into it. So I don't know. Yeah, so this is about the opening, right? And of course, I'm not going to reveal my full strategy, but just to give an idea, right, of what is possible in this round. Yes, so I'm just trying to see how I frame this. Yeah, so this was just to give context of why the pipeline started looking into these subgraphs. It was because it got flagged. I ingest the transcripts of the demos, and I said, yes, I said in one of the demos, or two of the demos, that I talked about this hearing, this supposed hearing for December 2nd. Okay, in one of the demos, I said that there was going to be a hearing. It's not really a hearing; it's a proceeding via submission. But they applied the deceptive title TTP under that document to confuse me, right, and create this narrative that I'm a difficult litigant, right? That it's not that they're committing crimes; it's just that I'm difficult. So that was one thing, but my demos got flagged by the anti-manipulation pipeline as contradictory, which was funny, right? Because my own demos got flagged. But they got flagged because I made this comment about the hearing, and in another demo, I made a comment saying that they can't have a hearing with me because they know that I'm going to say things on the record that will incriminate them, right? That will put them on a bind. And they can allow me to talk to a microphone, obviously. So from this point on, everything they do has to do via electronic means. They can't put me in front of a microphone. So these two statements are contradictory, right? I said one thing, that they were not going to put me in front of the microphone, and then in another demo, I said that there's a hearing on December 2nd, and these two contradictions got flagged, right? And this triggered the pipeline to look into the docket, I mean, just describing as if it was a human, right? But all this happened with software. But that this particular supposed hearing of December 2nd was not it's not in the docket, right? Like if you look at the docket for December 2nd, there is no hearing. And all the other hearings are recorded in the dates, right? Like you see this one, it says temporary orders hearing on September 8th, right? So the hearings are marked in the docket, but the thing that I said that for December 2nd is not. So this increased the score of that document, and when the pipeline look at the document, it turns out it's a deceptive title technique, right? They did it better this time, right? Like it was better done than what they did before with the temporary orders, notice of entry dash temporary orders, right? That was more obvious. This one, they made the paragraph longer and they put the other things below the 5th paragraph, which sounds like they adapted, right, to what I said about the technique of finding. So the Heiner boost, they adapted the document to defeat the Heiner boost, which is also interesting on itself, right? This document, if you look at the structure of the document, it defeats the Heiner boost. That's why it didn't got flagged on the first pass, right? Because it did not trigger Heiner boost, but it got triggered because the anti-manipulation pipeline flagged my demos, right, regarding this particular topic. So it was an interesting set of sequence of a chain of events, right? From an engineering point of view, it's very interesting to me that this is what ended up happening. But to not give too much more time to this topic, I want to show you the end result of this, what the pipeline generated, right? The document that I filed ultimately. It's here in actions taken against the war fraud. So is this one consolidated objections to the motion to withdraw and a fifth amended and superseding motion for sanction. So this is a brilliant move, right, of the pipeline, because what the pipeline is doing really is piggybacking on the thing that they put in motion themselves to insert these amended motion for sanctions with these grave accusations of wire fraud, right? And it details here the hard evidence, right? The filing of November 7 of Troy Pickett and the email of Morgan Heibner demanding payment by electronic means based on this fraud, right? And the email is here, and you can say where she says here, please send to Mrs. Espina the payment for the apartment that was due on 10/1/2025, and please ensure that the child daycare is paid. So she's making explicit monetary demands based on this fraud. And also interesting here, she says, she's trying to explain, and this shows the deceptive intent here, right? So she's saying that the hearing on the 8th of September was that orders were rendered in that hearing, right? And she's saying that then we came back on the 11th to continue the rendering, right? So she's deceiving me here to make me believe, I'm a proselytic, right? Supposedly, I mean, she has to assume that I don't know the law, right? So she's using that to take advantage of me. She is trying to make me believe that what happened on the 8th was an order rendering hearing, right? But it was not. It was a hearing to hear arguments, and you can see that in the docket. If you go to September 8th, right? It says temporary order hearing, right? Temporary orders hearing. It's a hearing to hear arguments. It's not a hearing to render orders. And then the judge puts in here that we attended the hearing, right? And that the matters are taken under advisement. He's saying here clearly with his, and he initialed this, that no orders were rendered. There's no orders in here, right? Everything, it says the court heard petition and motion for attorney's fee and took it under advisement. Like no orders were rendered here, right? And also, in the unofficial transcript that I have of this hearing, the judge says on the other hearing, sorry, on the September 11th, right? So the one that happened 2 days later, which is September 11th, this one, right? This one over here. The judge says on September 11th, the first thing he says, okay, the court is now ready to render its orders. That's the first thing he says. So it's clear that the hearing of September 11th was the order, that was the hearing where the orders were rendered, right? And not only that, if you see and this is also, and all this evidence is in the same document that I filed with the court, right? In this, so this is the fraudulent void order, right? That you can see the timestamp. It was really filed 13 days before it was signed, right? So they just signed it, but they didn't file it. It doesn't have the stamp on the 15th, right? It's not there. And the certificate of service also has timestamps that predate the 15 by weeks, right? So this is fraudulent. But in the first paragraph, it says on September 8th, the court heard the petitioner's motion for temporary orders. It doesn't say the court rendered any orders on September 8th. It heard, right? So there's so much evidence that says that what happened on the 8th was a hearing on the substantive matters. It wasn't a rendering of orders. No orders were rendered, and they're not recorded in the docket anywhere. Yet, Morgan Heibner makes this demand, right, on this email, deceiving me, right? Saying we came back for the remaining court's decisions on September 11th. So she's deceiving me. She's trying to make me believe that what happened on the 8th was a rendition of orders, which is not the case. It's clearly said in the docket. It's said on their own order, and there's no orders recorded in the docket on September 8th. And it clearly says, signed by the judge, that everything was taken under advisement, right? So here you can see in this email that Morgan Heimner is lying to deceive me, to deprive me of property, using electronic means, because you can see it's a Gmail email, right? So she sent this via email, and Google is Gmail is controlled by Google, who is headquartered in California, right? So she's using interstate wires to deceive me, to deprive me of property and money. So this is the textbooks, the penal code, really, definition of wire fraud. So in this document, right, I'm making that argument, and the same applies with Pickett, which I'm not going to read it because I did this in another demo, but he filed on November 7th a document saying, admitting that he represented 2 different times of signing the orders to 2 different courts to get favorable rulings based on procedural things. Which means that he knew that fraud was committed, and yet he was seeking enforcement of those orders, which contain explicit demands for money and property. So, this document that the pipeline built is a nuclear weapon, right? Because it clearly talks about wire fraud, right? It has all the elements. Element 1 is the scheme and the intent to defraud, right? And it's clearly spelled out here. Element 2 is the use of interstate wire communications. And it also details the cover-up, obstruction, and collusion. And this is because when Morgan Heimner tries to leave the case, I respond saying she's in default of the second discovery request. I filed a discovery request that she never replied to, because it contains, the answers might be damaging to the other side. So she ignored it, right? And I said she's in default, therefore she cannot leave the case. The next day, Troy Pickett filed the response to that discovery request, which, if you think about it, right, shows collusion, because Morgan Heimner should file her own response to the discovery request that was filed, that was served to her. I didn't serve that discovery request to Pickett because Pickett wasn't even in the case, right? But he's doing this to clear the way, so that is not an issue, and Morgan Heimner could be left of the case, and really the Adams law firm, right? What they want to do is to remove the name Adams from the fraud on the lower court, right? Because it's too complicated to have too many Adams names in the lower court, right? And then also in the appellate court, and this fraud was committed. Right? It's a complicated situation to explain. So what they want to do is to remove the Adams from the lower court. So, but this shows that Troy Pickett is acting in collusion, because otherwise Morgan Heimner should have fulfilled her own obligation to be able to leave the case. Why is Troy Pickett fulfilling her obligation, right? And not only that, I also filed in that email that I received from Adobe that shows clearly here at the bottom that Troy Pickett has the power to cancel agreements of the Adams law firm, right? So this shows collusion, right? It's a scheme of multiple individuals participating in concert. Now, but again, going back to the software conversation, what I find beautiful about this is that the pipeline gave me the 2 avenues, right? You can pursue and ask for jail time in the sanctions, right? But and this is the human thinking, right? I know what's happening because I'm looking at the diagram, right? At the directed graph that I showed you. I know that the situation is to keep me trapped in the lower court. And if I choose this avenue, what I'm doing is trapping myself. I'm going to be kept in this, litigating this issue, and it's not going to go anywhere, right? So I have to go on the other direction, right? So I didn't ask for jail time based on their own fraudulent order, but I spelled out all the ingredients for wire fraud, which is a federal crime, right? So now this is where things get more interesting. I filed this document today, right? And I'm proud of the pipeline, and it gets rejected, right? None of my filing has gotten rejected before, and none for this reason. And this got rejected for a very interesting reason. Look at this. I'm going to show you this. It got rejected, listen to this, because the paper size was not set in the metadata of the file. It's not that the paper size was wrong, because I made sure that the paper size is wrong. But in that particular file that I submitted. And you can see that here, right? So this came from the court, right? From the clerk. It says, incorrect formatting. Please resubmit with a page size of 8.5 by 11, according to TRCP 91F8. Right? So again, a procedural, they're rejecting, but now this is a lower level. They're doing it with the clerk, right? The clerk is rejecting the filing because supposedly it doesn't have the right format, but it's not true. Like the file, the paper size is correct. It's just the metadata wasn't set. But this is very interesting because it means, this is a very technical clerk. They are looking at the metadata of the file, right? If I ever, run a company and need a clerk to do clerical work for my company, I want to have a clerk like this, right? That looks into the metadata of the files to make decisions. It's amazing to me, right? And again, it's the first time in the 8 months, and I produced these documents with the same pipeline. I didn't make any changes to the pipeline. This means that the other document that I filed recently have had the same problem, but they did not get rejected. They did not have the metadata set, but they did not get rejected. This got rejected. The reason is because this particular document contains the checkmate move that they can't escape, right? So they have to do something like this. Immediately when I see this, my response was, okay. So I put the metadata in the file and I resubmit it, but I also serve directly, because what they're trying to do is to get the judge not be served, right? Because as long as the judge is not served, the judge can claim ignorance, right? I didn't know this was happening, right? So what I did, I took the same document, I refiled it, but at the same time, I served the judge directly and I served the clerk, right? So both know that these serious allegations are in here, even if the document is not yet accepted. It's, I guess, right? I imagine federal authorities will not care if the document was really filed or accepted. What matters is if the judge was aware or not that wire fraud was committed by Troy Pickett, Morgan Heibner, and the Adams law firm. That is the question. It's not the question whether the document was filed. It's silly. If you think about it, this is silly. They're acting like children at this point, right? That will not matter, right? And in fact, whether the document is affected or not is agnostic, or it doesn't matter, right? To the federal court or to the FBI, like, it doesn't matter, right? As long as the judge is aware, he has a responsibility to act. So I serve him directly, right? And I'm going to show this here so you can see that I took this action, right? Yes. So you can see here that I serve. So this is a serve only, and you can see here, right? Service only, because I already filed it, the corrected version with the metadata, but I also served it. So just in case, right, they don't do the same thing that they did on October 16, that at 11 p.m., they enter the order, right? That's why when I started this demo, I read the time and I told you at this time, I think it was 8:50 p.m., nothing has been entered, right? To demonstrate in this demo and timestamp it that they haven't taken an action, and I already filed this document and I already served the judge, right? So after this point, after this time where I sent this at 7:46, this time is wrong because that computer has a different time zone, and I do that intention. But the real time of service was 7:46 p.m. Central Time. So, if the judge takes any action on that motion of Morgan Heimer to withdraw after 7:46 p.m. of December 2nd, 2025, he made that decision being aware, because I serve him, right, directly to the email of the court. And I also serve the clerk, right? And I serve myself to have a copy of this, right? And I also want to show you that when I served the judge, I also took a screenshot to show you. I put a note in the filing, right? And I have the screenshot here. I said serving the court directly because the filing today was rejected on a technicality that the paper size 8 by 11 inches was not explicitly set on the metadata of the file. Parenthesis, the paper size was correct, comma, just not explicitly declared in the metadata. Since the allegations contained herein are serious and urgent, I'm serving the court and the clerk directly, right? So I'm telling them there is something serious in this filing and urgent, and I'm serving you directly, right? So after this point, if they make a decision on that and let Morgan Heibner leave the case, despite the serious allegations of wire fraud, there's no other way to call it. Well, I guess that is something that they will have to explain at some point, right? But they cannot say that they were not aware, right? Because I made sure that they are aware. But super interesting to me that the vector to delay this, because they're not gonna make it go away, right? They can only delay it, right? Was the paper size on the metadata of the file. It's super interesting. Now, this is not a smoking gun or anything. I mean, what I want to say next, but it's an interesting thing that I observed. I noticed that in the Tyler Tech system, they lower the maximum size of the attachment permitted. I mean, this is mind blowing. Of course, I can't prove that this was intentional, right? The same thing as I said before, that technology companies have a lot of freedom of what they can do with their systems because they own them, right? They have no accountability to anybody, but they're shareholders. Right? And if they're controlled by the Communist Party of China, they have accountability to the Communist Party of China, right? But before today, this court in the e-filing system of Tyler Tech had a size limit of 2 gigabytes, right? So I could attach super large files. This is important because in my pipeline, it has a reduction system, right? That I use to redact the documents, and it produces files in which the PDF file is basically assembled, and I'm going to give you details here because they might be important, right? Are assembled as images, right? And this is important for different reasons, but the result of this is that the file size is large. It's around 40 to 50 megabytes because these filings contain the fraudulent orders that are 35 pages long, full of fabrications made by the Adams Law Firm and Troy Pickett that were never rendered by the judge, but it's 35 pages of images, right? If it's 35 images, large images, right? So the file size is going to be always above 40 megabytes, right? So today, this happened today. Like when the last document I filed, maybe 2 days ago, this restriction wasn't there for this court. I saw it in a different court, in the Supreme Court, that the size was 16 megabytes. But today, on the 387, the size is also 16 megabytes. Right? So this makes it impossible for me to upload documents that contain the orders, right? So I think it's a way, right? It's a way to, and this is why I had to format the document with this other system that strip unintentionally, right? Strip the metadata. I didn't notice that I basically have another system that optimizes the images so they fit within the 16 megabytes of the Supreme Court limit, right? But that system strips the metadata on the resulting PDF, and they exploited this, right? So I think that the lowering of the limit on the Tyler Tech system to 60 megabytes was designed because they foresaw that I would use the optimization system that I have to lower the size of the file, which as a byproduct will remove the metadata of the file, including the paper size. And that would justify the clerk dismissing it if they needed to, right? So of course, it's a theory. I can't prove it, right? Because I don't work for Tyler Tech. But it seemed to me very convenient that they lowered that file size today, right? It had been 2 gigabytes, and the difference between, so 2 gigabytes is 2,000 megabytes. So they lowered it from 2,000 to 16. It's an order of magnitude below, right? I mean, if they have the capability to do this at 2 gigabytes, what justification could there be to degrade the user experience for everybody, supposedly, right? I have to imagine that this happens to everybody. I don't think it's going to be targeted to me specifically, right? I don't know if they will have the capability. But anyhow, what could justify degrading the user experience of everybody in Texas in such a way that now nobody can upload files of 2 gigabytes, but only 16 gigabytes, or only 16 megabytes? I don't know. It's amazing to see. Yes. Okay. So yeah, so this session is getting kind of long. So I'm going to, I'm, I still have the on the ground observations. I'm gonna probably move those to another session. But there's a couple of things that I want to mention that because they fall on the legal thing, right? So I'm gonna move them to here, and I'm gonna talk about this quickly. So one is what I call the "we have all that" comment. This is something that happened when I went to give the courtesy copy of the folder with all the supplements to the motion, the second motion to recuse. I gave that courtesy copy to the clerk of Judge Brown. Again, Judge Brown is a judge that was appointed by Governor Greg Abbott, and the clerk, her name is Rebecca Bright, Brite. So when I get there, right, so the 11th court is very interesting because it doesn't have a filing window. Like if you want to file a document, you can't. There's no way a citizen can file a document with that court, which is mesmerizing. I mean, it blows my mind to see that the court doesn't have a filing capabilities, right? They only accept documents forwarded by other courts. But anyhow, I go there, right? So I see that I cannot give them the courtesy copy, and I wanted to give it them because I'm hoping to be heard, right? I'm hoping to get a hearing on this. I get there, I see that I cannot file it. I cannot give the copy to anybody. So I call the court, and Mrs. Bright, the clerk, or the assistant, executive assistant, I think it's called. She answers, right? And I said, my name is Rinaldo. I'm a pro se litigant. I would like to deliver a courtesy copy. And, she says, well, when do I accept copies? And I say, well, this is a serious matter. There's a child whose welfare is at stake. Would you allow me to give this copy to you? I'm at the lobby. And then she agreed. She came down, right? When she comes out of the elevator, I give her the copy and I open the folder and I show her 3 or 4 of the supplements, right? And she looks at them and she says, yes, we have all this. We have all that. This is what she says, right? Now, that comment struck me as odd because and I don't know how to articulate this idea, but the feeling is that how could she know me? I mean, it felt like she knew who I was. And I didn't say my last name. I didn't say what the case was. And I have to imagine if Judge Brown is a judge that is administering other courts, right, across Texas, she must be very busy. Like, I cannot possibly be the only litigant that has a matter in front of her, right? So how was Mrs. Bright so quickly aware of my case when I didn't give her any details? I just said a child, right? There's a child whose welfare is at stake. That's all I said, right? And my first name. But she not only recognized the case, but she recognized the documents that they supposedly already had. She was able to compare in the lobby by me just showing quickly these documents. She was able to make the conclusion that they already had all those documents. I mean, this was amazing to me, right? But what this suggested to me when I saw this is that they knew that this is not a regular case as they're trying to portray, right? I mean, when I say that, I mean the lower courts, right? This is something that is being orchestrated, right? And they are highly aware of what's happening. So that's we have all that comment. So I just wanted to put that on the record. And the second thing that I want to put on the record is this. This is very interesting, right? So I went to the federal court yesterday, right? And I filed with the federal court a notice so to put in the record on the federal court, the filing I made with the Supreme Court of Texas. And this is related to that directed graph of liability that I showed you before. The idea was to increase the level of awareness of the Supreme Court by 1 point, right? So this is what I'm doing. I'm going by rounds, right? I'm increasing the level of awareness of everybody in rounds, in intentional ways, right? I'm not doing this randomly. I'm doing this with software, well, designed with software assisted design, right? So I filed that, right? So now the federal court is aware of the Supreme Court having an instrument, and you can see that in this arrow, right? So basically, yesterday I filed this arrow. That's what I'm saying. That was yesterday, right? And in the same filing, I filed for a motion. I filed a motion, or I prayed the court to. I urged the court to rule on the pending motions. There are 2 or 3 pending motions before the federal court on that docket, which is the class action against Elon Musk and Wilmer Ruperti and a bunch of other people. Excuse me. And those motions have been pending for ruling for months. 2 motions against those are very important, right? One is the motion for e-filing access. In the federal court, at least in this federal court, Southern District of Texas, pro se litigants do not have the right to use e-filing systems. You have to file in paper. This puts me at a disadvantage and risk, because every time I have to drive to the federal court is almost 3 hours round trip, right? And these agents of Diosdado Cabello are following me every second, right? And harassing me in the process, right? And in one occasion, they tampered with my vehicle when the vehicle was parked outside of the court, right? Of the federal court. So it's a dangerous situation, right? So and that's why I filed I filed a motion months ago asking for access to e-file, right, for this token. It has never been ruled on, right? And the other motion that is important is the motion to extend the time for service. And this is because there's a time, I think it's 90 days, right? After you file in federal court, you have 90 days to serve the respondents. But because they kidnapped my son, I did not have a chance to, take care of that, right? So my priority has been recovering my son, right? So anyhow, I filed a motion with this court asking for an extension of the time to serve the respondents. And that motion hasn't been ruled on. On the other side, also on the docket, there was a note made by the clerk saying that the initial conference was rescheduled because I had not served the respondents, right? And I said in one of the demos that I would take this an authorization to serve them, and I would serve them. But this statement that I made was also flagged by my own pipeline. It said that what I was saying was incorrect, and it was flagged by the anti-manipulation pipeline, that it was not true, right? I mean, my statement was inaccurate. It was flagged as a deception, because I cannot make that. I cannot say that comment by a clerk in a docket is an authorization to serve the respondents. And if I serve the respondents, I would be creating an invalid service, and that would be a valid excuse or reason to get the lawsuit dismissed, right? So I cannot serve the respondents unless the judge rules on my motion to extend the time of service, right? So it's a catch-22 situation that is being created in that court. They're telling me you are not serving them, so they could get it dismissed because I didn't serve them. But if I serve them, then their attorneys could get it dismissed because the service was improper, right? So in that document that I filed yesterday, I said 2 things. One, please rule on the pending motions, particularly these 2 motions. The e-filing, because the network, the transnational criminal enterprise that I'm denouncing, has marked my 2 houses as vacant, so I don't get any mail. So I cannot meaningfully participate in these proceedings if I don't have access to the mail system of the US, because they blocked me, right? So this is a reason for me this is a reason that explains why I need desperately e-filing access, right? So that was my first prayer, right? The second prayer was, please rule on the motion for extension to serve, because I'm under the impression that if I do serve them without permission from a judge, because of the need for the extension, the opposing counsel could file a motion to get the entire lawsuit dismissed based on a procedural error, that I served the respondents outside of the 90 days window. Um, so I filed that thing yesterday, right? But the interesting thing I want to say is what happened today. So today, the second most interesting mailman in the world. I said second. I should explain that. Sometimes I give affectionate names to these agents that harass me. So there's one that was the most interesting mailman in the world, right? Which was who was the mailman in Lake Point State around July 2024 when I moved here. He was a Russian, clearly a Russian agent, right? Um, and I describe him in the books and the different things and in the website, but they changed him, right? So this is a different mailman. So this is why this is the second most interesting mailman in the world. So now, this second most interesting mailman in the world, when I'm going to the federal court yesterday, he intercepted me outside of my home. Like he was conveniently passing in front of my home at the exact moment I was going to the federal court. So of course, what I did, I stopped him and I asked him if he could resume service to my house, right? And he gave me the card and I filled it, and this got recorded in the cameras, by the way, in the cameras of the call mobile. But anyhow, I filed this instrument in the federal court yesterday, and today he comes knocking on my door and he gives me this little number, right? I don't know if you will be able to say it there. I'm going to try to put it here so you can say it, right? But this is an interesting envelope, right? Let me tell you why. So, well, it's certified mail, right? And it's coming from Roberts, Markel, Weinberg, Butler, Haley, PC. This is the law firm that Agent Phil Denning, who works with Robert Mueller, right, for the network, has been using for a year to harass me, right, with a lawsuit and So they supposedly, right? So they sent me this register mail, right, that arrived today conveniently. The next day, after I complained in federal court saying that they had marked my houses as vacant, right? So the guy, the second most interesting mailman in the world, he asked me to sign with my signature that I received this, right? So I believe it's a way for them to create a record that no, my house is not marked as vacant, and now this law firm has a proof, right? Because they have the registered mail signature that I accepted the mail today after I said that on federal court yesterday, right? But it gets more interesting. This envelope, because like think about it, how could they have created this in a day, right? It's hard to pull off. So if I look at the envelope, it says vacant, right? It's marked as vacant, but he delivered this to me today. So I mean, this is very telling, right? So what happened was this was sent to me before yesterday, right? And it was marked as vacant, and it was in the USPS deep, right? That serves this area. But because I filed the document yesterday, then they went and dig this little number from the pile of vacant letters that they have, right? That mark as vacant, right? Because they marked my house as vacant months ago. So they took this one, which would create a record, right, for them to defend, right, that they are not doing this intentionally and they did not mark my house as vacant, all that, right? They took this and he delivered it to me, right? But he chose this one because this is the one that would create a digital record for the lawyers, right? That would be in possession of the lawyers to defend or to attack what I'm saying, right, in court, in the federal court. But this is interesting because this should be traceable, right? When was this letter really mailed, right? Um, I don't know if it has a postmark that I can see. No, no, it doesn't have. And sometimes when this should be postmarked, right? It should have a date when it was processed. It doesn't have. But it should be It has a number, right? I'm going to say the number here. It says USPS certified mail, and it says 9214-8901-4298-0435 3686-84. In fact, I don't know. Let's do that exercise right here. Let's see. USPS certified mail tracking. I don't know if I can track it this way, but let's try. I don't know. 9214 8901 4298 0435 3686 84. Yeah, see, exactly what I was telling you, right? So it was marked as vacant on November 24, and he chose to deliver this to me a week after I went to federal court and complained about they marking my house as vacant. I mean, it's cause and effect. I mean, this shows that the mailman is in it, right? And this was actually sent on November 21st, right? Uh, so this is very telling, right? This is a direct reaction to my filing yesterday in federal court. Because of all the mail that could be marked as vacant in the USPS, holding facility, whatever, they choose this one, right? He didn't bring me anything else but this one, which is certified mail and is coming from the lawyers, right? Because they need the proof. They need to be able to have a proof that my house is not vacant, and they also need that they can explain why they have that proof, right? So I'm not gonna open it to not to preserve the forensic value that it could have. I mean, there might be fingerprints inside. I'm not gonna destroy them, and also to give them the opportunity. I mean, imagine it's related to that lawsuit that they created for $3,000, right? And I don't know, the informant told me a long time ago that they had entered a default judgment, and I don't know exactly the details, but if they seek enforcement of that, they will be going into the same group with Pickett, right? So I'm curious to see if they learn from the mistake of Pickett of seeking enforcement for something that they created fraudulently, and or if they're going to seek enforcement of that. So I don't know. I'm kind of waiting to see what they do. But maybe this is a good point to say this, right? Because we're talking about this. So this is the law firm that represents Phil Denning and the HOA, that that is basically the Association of Agents of Lake Pond Estates. They had a little project last year in which they said that they were going to replace the fences, which is not true, right? For obvious reasons, because they cannot replace the fences because that would open them to the FBI insert people. Sorry, the timer. That would open themselves to insert to the FBI inserting agents into the backyard of Robert Mueller. They're never going to replace the fence, right? But they made a series of monetary demands in writing, asking me for $18,000 to supposedly replace the fence, right? And they said that it was in 3 installments. So I sent them, I don't know, I don't recall the amount, like 6,000, 7,000, I don't recall exactly the amount, but it was in the thousands of dollars. I sent the first installment a year ago, more than a year ago, and they haven't replaced the fence, and they haven't sent me my money back, right? That thing was just a technique of harassment, right? To harass me by making me think that they were going to bring down the fence that is protecting my house, right? And knowing that they're harassing me, right? That obviously they think that would put me under stress, but I know they can't replace the fence because that would mean opening the fences of all the agents in Lake Pond Estates and open them to the FBI intruding right into their properties. So I don't know. That's an interesting one. Now, another thing that is interesting is that this mail is directed to the company, because this house is owned by the company, right? The company that publishes the book that they want to silence, and the company name is Haaretz Hamuf Lachat Corp. Right? That's the name I put the company, and that means promised land, right? Because I knew that I knew who I was dealing with when I registered this company. So this is interesting because in the card that I filled yesterday and gave to the mailman, I did not put this name in that card. I put my last name only. I put Aguiar Marcano and Aguiar Marcano, right? So the different combinations of my 2 last names. I did not put the company name because it's too complicated to spell. I have to. I mean, I don't speak Hebrew. I have to read it to be able to type it, right? To write it down. So I did not put that in the card. So he basically got from the pile of vacant mail that has been there for weeks a letter that is not even addressed to the names that I put in the card, right? So obviously somebody is directing the second most interesting mailman in the world. And you can see that that this was picked from a pile of vacant mail to come today to my home to to create this record, right? So they can say in federal court that I'm hallucinating, right? That my house is not marked as vacant, but by them, right? But this shows that who is behind this, right? It has to be Roberts, Markle, Weinberg, Butler, Haley, PC, right? There's no other. I mean, they chose their own letter, right? So anyhow, with this, I'm going to close this demo. I think it was a very exciting session, at least for me, right? It was very interesting to talk about these topics. And I'm still indebted on the more on the ground observations, but I'm gonna try to do that tomorrow morning. Okay. Well, thank you so much for your time. Have a good night, and I'll see you on the next one.